So there was a very interesting paragraph in the judgment of the Delhi High Court, a very recent judgment in Najma versus Government of NCT of Delhi, 2021, SEC Online, Delhi 3775. The date of judgment is 22nd July 2021. So there the bench observes that in the social context, promises are kept only to be broken. But in the legal context, we have evolved the principle of legitimate expectation and the principle of promissory estoppel, through which the government, its functionaries and its representatives acting in their official capacity are bound by the promises that they make. And these promises, subject to certain conditions, are enforceable in the court of law. So this is the crux of the concept of legitimate expectation. But let me first tell you the facts of this case. So the Chief Minister of Delhi, in the wake of the COVID pandemic, gives a press conference. So let us see what he says. This is on 29th of March 2020. So this is the transcript of the press conference. A few days ago, I had asked the landlords to postpone the rent of impoverished tenants, unable to pay rent for 2 to 3 months and not take immediate payment. Today, I am appealing to you and the landlords of the entire Delhi. If you consider me your son or brother, then all the landlords must talk to their tenants and ask them to rest assured that you are with them and won't force them to pay rent. Today, all of you must go and give assurance to them. There has been news from some places that a few landlords are forcing their tenants, due to which they are evacuating and leaving. Please don't force them. Kindly postpone their rent. In a month or two, when this corona, and let's assume after this entire mess is over, if a tenant has been unable to pay rent due to poverty, I assure you that the government will pay for it. I am talking about those tenants who may be unable to pay some of their rent due to lack of means. However, no landlord will force them right now, and if they do so, then the government will take strict action against them. So this is what the Chief Minister of Delhi had said in this press conference. Now, writ petitions were filed. Some were filed by tenants and one was filed by a landlord. What was the contention of the tenants? The tenants said that this press conference and this statement, that if the tenants out of poverty are not able to pay the rent, then the government will pay it. That sentence given by the Chief Minister amounted to a solemn promise, which induced in them a legitimate expectation that if they are not able to pay the rent, then the government will pay. Therefore, they sought enforcement of that promise. The landlord says that, see, the Chief Minister gave a promise. The Chief Minister asked me not to take the rent now, to postpone the collection of rent. He induced in me a legitimate expectation that if my tenant is not able to pay the rent, then later the government would pay for it. Therefore, I seek enforcement of that promise. So this was the contention before the Delhi High Court. The question as to whether this legitimate expectation on the part of the tenants and landlord is judicially enforceable was the question. Now, what was decided in this case, I shall tell you at the end of the lecture. Firstly, we will look at in a nutshell as to what is the concept of legitimate expectation. Then we will look at the English law that governs this doctrine. The reason we look at the English law is because that is where the concept of legitimate expectation originated from. Doctrine of legitimate expectation owes its origin from the judicial decisions of the courts of England. It is not from any statute. There is no statute which embodies the doctrine of legitimate expectation, neither here nor in England. So then after that, we will look at the application of this doctrine by the courts in India. And then we will understand what is the scope of doctrine of legitimate expectation here. And then finally, I shall tell you if the government of Delhi had to pay the rent of the tenant or not. So what is this concept of legitimate expectation? Now, if the government or its functionary or its officials, or in other words, the instrumentalities of the government, acting in their official capacity, make a promise. That promise may be made to a single citizen, it may be to a section or a community of people, or it may be to the entire citizenry as a whole. Now, if that promise induces in the promisee an expectation that it will be fulfilled, then the government goes back on its promise. It resiles from its promise. Then, because it induced in the promisee an expectation that the promise will be fulfilled, this doctrine of legitimate expectation gives him a cause of action to try and get his promise enforced in the court of law. In other words, if the administrative decision of the government, when the government is acting in its administrative powers, while acting in its administrative powers, the government goes back on an earlier promise which was made to any person, which induced in him an expectation that that promise will be fulfilled, then this doctrine of legitimate expectation gives the person a cause of action to try and enforce it in the court of law. Now, whether every expectation is enforceable or not, no. That depends on the facts and circumstances of the case. The enforceability of every legitimate expectation depends on each case's facts and circumstances. There is no concept of precedent here. So the expectation very obviously should be legitimate. That is the first criteria. Because every expectation need not be legitimate, or in other words, every expectation need not be reasonable, need not be valid. It need not be founded on a promise. So it is essential that an expectation is reasonable, valid, and founded on a promise, or in other words, legitimate for it to be enforced. Now, the second question is whether only an express promise which is made by the government can be enforced, whether only such a promise can induce a legitimate expectation. No, it is not only an express promise, but it is also a regular and consistent conduct or practice that the government and its instrumentalities follow that can also induce a legitimate expectation. And in appropriate cases, that can also be enforced by the court of law. So what are the two types of legitimate expectation that a person can have? A person can have a substantive legitimate expectation, or a person can have a procedural legitimate expectation. What is a substantive legitimate expectation? When a promise or a conduct or a practice by the government induces in a person that they are entitled to a particular benefit or a particular outcome, then it is called as a substantive legitimate expectation. Let us take the case of these tenants. These tenants had a legitimate expectation because of the promise which was made by the chief minister that their rent would be paid. That is, they would be entitled to some benefit. Therefore, that is called as a substantive legitimate expectation. Whereas on the other hand, if a promise, conduct, or practice of the government and its officials induces in a person that they will be heard before a decision is taken, then that is called procedural legitimate expectation. There, a person's legitimate expectation is not that they will be receiving some benefit or outcome. It is only that they will be heard before the decision is taken. So these are the two types of legitimate expectation. So when a person seeks to enforce any of these two types of legitimate expectation, what is it that the court will see? Firstly, the court will see the nature and scope of the promise that was made by the government. Now, in this case, in the Delhi High Court case, the court will see what was the express terms of the promise that was made by the chief minister. What was its scope? Whether the chief minister said that only the rent of only a few very poor citizens would be paid, or whether the rent of most of the tenants would be paid. So what is the nature and scope of the promise is first going to be seen. Secondly, the circumstances under which the promise is made. Now, in this judgment, the court will see as to whether the promise was made at an election rally, or whether the promise was made at a specific press conference which was called to address this particular issue. Now, if this promise was made at an election rally, all of us know that it is not going to be enforceable. Every promise which is made at a campaign or an election rally cannot be enforced by anybody. So therefore, the circumstances under which the promise is made is very important. And third, the statutory or other kind of discretion which is available to the authority. That will also be seen. So depending on the facts and circumstance, what was the extent of discretion that was available to an authority? That is very important to understand the enforceability of the promise. So the court will see these factors and decide on the legitimacy of a person's expectation. Now, when the court concludes that yes, there is a legitimate expectation that was broken by the government, whether it is automatically enforceable? No. There are adequate defenses that are available on the side of the government as well. The most common being overriding public interest. That is the most common defense which is put up by the government to resile from a promise. There are other factors as well, like bona fide, a reasonable decision, etc. But the most common is an overriding public interest. Therefore, the court will have to weigh the legitimate expectation of the person and the defense that is available to the government, and then decide whether the promise should be enforced. Sometimes the court may say that a person is entitled to a substantive legitimate expectation, that is, he is entitled to a particular outcome. Sometimes the court may say that he is only entitled to a right of hearing, whereas in other cases the court will dismiss the writ petition and say there is no claim of legitimate expectation that is enforceable. So this is, in a nutshell, the concept of legitimate expectation. But to understand it further, to understand the extent of judicial review, to understand its application, we have to look at the case laws. So as I said, first let us just have a brief look as to what is the English position with respect to the doctrine of legitimate expectation. So one of the seminal cases which is cited everywhere, be it in subsequent judgments of England as well as judgments of the Honorable Supreme Court of India, including the very recent judgment in Brahmaputra Metallics versus State of Jharkhand, which I will be dealing with a little later. So that judgment also cites this judgment, which is R versus North and East Devon Authority, 2001 QB 213. So in this case, an old, severely disabled lady was admitted into a nursing home, which was run by the National Health Service Facility. We know that in UK, they have a nationalized system of healthcare. So therefore, this is, of course, a facility which is under the government, the health authority. So she was admitted into that facility and she was there for a considerable period of time. But suddenly, the health authority decided to close down the nursing home. They felt that it was financially not feasible to continue to run the nursing home. Now, this lady goes to the court and says, see, when I joined this nursing home, it was represented to me that I would be allowed to stay there until my last breath. So therefore, turning me out now amounts to destroying the legitimate expectation that I had. And therefore, this decision ought to be quashed. And she prayed for a writ of certiorari. the High Court allowed her claim. And when it came in appeal before the Court of Appeals, the Court of Appeals gave a very elaborate judgment. They first said that when in any plea of legitimate expectation is put up, three things have to be seen. I think I've already told you that. First is a detailed examination of the promise. Second, circumstances in which the promise is made. Third is the statutory or administrative discretion. And then they said that once the court looks at these factors, there are three different kinds of outcomes that the court can come into. Firstly, the court may decide that yes, there is an enforceable substantive legitimate expectation, as in this case. The court felt, after looking at the facts and circumstances, that there was a very clear promise that was made by the health authority, that the lady would be allowed to stay there until her death. And also, they noted the circumstances in which the promise was made. The promise was made to a very specific number of people. It was not a general open promise that was made. It was a promise made to a specific number of people that all of them would be allowed to stay there. And what was the difference that the government put up? The only difference that the government put up was financial considerations, which the court felt was not enough. Because the court held that when it is found that there is an enforceable substantive legitimate expectation, the extent of judicial review is going to be very strict. It is going to be high, in the sense that the court will in most cases enforce that legitimate expectation unless there is any overriding interest to stop them from enforcing it. So here the only difference was financial consideration, which the court felt did not amount to a sufficient overriding interest to defeat the lady's legitimate expectation. So the second outcome which a court may come to after analyzing the facts and circumstance is to hold that a person is entitled to a procedural legitimate expectation. Now, when it comes to procedural legitimate expectation, I have to cite another case, which is also cited in this judgment. Attorney General of Hong Kong versus Ng Yuen Shu. I do not know if I'm pronouncing the name correct, but the citation is 1983 to WLR 735. So in this case, the question was as to whether a person who had entered a country illegally, who had entered Hong Kong illegally, was entitled to a right of hearing before he was deported. Now, the judgment firstly notes that there is no statute or rule that mandates a right of hearing before a person who is illegally entered is deported. So in law, in the statute books, a person who has illegally entered Hong Kong has no right to be heard before he is deported. However, what had happened in that case was a group of illegal entrants, just like the petitioner, had gone to the immigration office with a representation saying that, they should not be thrown out of the country, etc. So when they went to the immigration office, a senior immigration official came out and he read out from a piece of paper, a statement. So when he read out the statement, he said many things. Like he said that, you will be, your documents will be checked and you may be asked to leave immediately, etc., etc. One particular line which he said was, each case will be decided on its own merits. So the petitioner is not physically present at that immigration office, but he watches this, which is telecasted on television. He watches this from his place of residence. And this line, each case will be decided on its own merits, proved to be crucial, because when the petitioner was denied a right of hearing, now he files a petition seeking judicial review, and he says that this statement that each case will be decided on its own merits implies that I will be given a right of hearing and I will be heard. I will be given an opportunity of representing, of submitting my defense, and only then will a decision be taken. And the court enforced that legitimate expectation even though in statute or in rules, he did not have a right of hearing. So this is a procedural legitimate expectation. So an express promise or a representation made by an authority can lead to a procedural legitimate expectation. And sometimes, as you will see in the Indian case laws, a past practice can also lead to a procedural legitimate expectation. If there is a consistent past practice, and then suddenly the government deviates from that practice, it is generally held that a right of hearing should be given. That, of course, in some cases, there are different opinions in different judicial dicta, of course. But that is procedural legitimate expectation. So this is the second kind of outcome which a court may come to after analyzing the facts and circumstances of the case. The third outcome is that, see, the court may see that, yes, there was a legitimate expectation and that expectation was defeated, but it does not amount to an enforceable legitimate expectation. So what they will check, they will only check if the authority has acted reasonably. They will apply the Wednesbury test. We all know that, the Wednesbury test, it's a very narrow test. It is only going to be looked at as to whether the authority has acted in a manner which is so unreasonable that no reasonable authority could have done so. So it is only that test that the court will follow. And the court will also look as to whether due consideration was given by the authority to previous practice or previous policy. So that a very narrow test is going to be used by the court in some cases, depending on the facts and circumstances. So what are the kind of cases that come under that category? That was clarified, in fact, in another case, in R versus Secretary of State for Education and Employment. They said that cases which fall into this category is where a large part of the population is affected and the change of policy will affect a macro political field. I can give you an example. If, for example, a new education policy is introduced in a country, now, as a result of the change in the education policy, the legitimate expectation of different people may be affected. Because it affects the entire population as a whole, every person will have a different legitimate expectation. And sometimes two people's legitimate expectation may be conflicting with each other. So in such cases, it is difficult to enforce each person's legitimate expectation, which will be different and distinct and conflicting. Similarly, in procedure also, before a policy that affects the entire country is changed, each and every person in the country cannot be given a right of hearing. So therefore, there, a procedural legitimate expectation is not in effect possible. So therefore, in such cases, when there is a change in policy that affects a macro political field, the court may come to the conclusion, depending on the facts and circumstances, that it is enough to check if the authority has acted in a very unreasonable manner. So these are the three kinds of outcomes according to this judgment, which a court can come into after analyzing the facts and circumstances of the case. So one more thing which I have to tell you, like I said before, even in England, it is not only an express promise that is enforceable. It was held in R versus Secretary of State of Transport that legitimate expectation may arise from an express promise, or it can be based on the existence of a regular practice or a conduct which the claimant can reasonably expect to continue. So in English law also, that of course the doctrine itself came from English law. So that is the position in English law, that even a consistent past practice can give rise to a legitimate expectation. Two other distinct features in English law is that all of us have also heard of the principle and the doctrine of promissory estoppel. So in English law, the doctrine of promissory estoppel operates in private law, and legitimate expectation operates in public law. So when private parties are concerned, promissory estoppel will apply, and when the state is concerned, it is always legitimate expectation. Second aspect to that is that promissory estoppel is necessary a remedy in equity. Therefore, if a person has to enforce the doctrine of promissory estoppel, he has to necessarily show that he has suffered some detriment as a result of the other party resiling from the promise. But that requirement to show detriment is not necessary in legitimate expectation. That is what has been held by the English courts. So if I have to enforce my right of legitimate expectation, I need not prove before the court of law that I have suffered a detriment or an injury as a result of the government resiling from its promise. So that, are the two, quite a clear distinction which is made between promissory estoppel and legitimate expectation. So this, in essence, is the English law that governs legitimate expectation. Now let us go to the Indian law. So I will be tracing out judgments from the year 1988 to the year 2021, a subject, of course, to time considerations. And we don't know how many judgments we can cover, but let us try and look at the position in India. So the first judgment is from the Kerala High Court, which went up to the Supreme Court. State of Kerala and others versus KG Madhavan Pillai and others. Citation is 1988, 4 SCC 669. All of you must have heard of this judgment. So the matter arises under the Kerala Education Rules. Now, Rule 2A of the Kerala Education Rules provided that the Director of Public Instruction could call for applications to open new schools or to upgrade existing schools. So after that, there is a procedure whereby the director scrutinizes the applications and then submits it to the government, and the government takes a decision and notifies the selected applicants in the official gazette. This happens under Rule 2. Then under Rule 11, after looking at the development plan, the government will give permission to the schools to start, commence their work. So there is no rule or provision, please note, in the Kerala education rules for the government to review the decision once it is taken. Okay. So then what happened? All these writ petitioners had submitted applications before the Director of Public Instruction. So Director of Public Instruction had approved their applications, recommended it to the government, and under Rule 2A, the government notified the list of selected applicants. After the government notified the list of selected applicants in the Gazette, but before under Rule 11, it was, the development plan was approved and before actual permission was given, the sanction list that was kept in abeyance because the general elections were announced. So the writ petitioners moved the High Court. And during the pendency of the writ petition, the new government came in. And the new government cancelled the complete list. So they revoked the complete list and they issued another notification, and they cited their reason for doing so. They said that, it was not feasible to open new schools and upgrade existing schools at this point of time during the end of the curriculum. There were some problems regarding absorption of teachers, etc. So therefore, they decided to revoke the selection list. So therefore, the writ petitioners challenged this decision, and single judge dismissed it. And when it came before the division bench allowed the writ appeals. And that was on the ground of natural justice, competence, etc. But when the state of Kerala came on appeal before the Supreme Court, an argument regarding legitimate expectation was raised. So there were two contentions that was taken in defense by the government of Kerala. The first contention was that, see, yes, a sanction order was given under Rule 2A, but permission to open the school was not given under Rule 11. So therefore, the right of legitimate expectation operates only after the permission is given under Rule 11. And the second contention was, under Section 20 of the Kerala General Clauses Act, and that corresponds to Section 21 of the General Clauses Act, the power to issue a notification includes the power to rescind or amend it. Therefore, even if in the Kerala education rules, there was no power to review the particular order. Under the under the General Clauses Act and the Kerala General Clauses Act as well as the Central Act, there is always the power to rescind a notification, to amend it, and that power is, in fact, it is an unlimited, untrammeled power. So that power can always be invoked and to defeat the right of legitimate expectation. Now, the bench refuted both these contentions. And what they said is, I will actually read out a portion of the judgment because I think it is important for us to understand straight away from the judgment. Mr. Pote's contention was that till the permission was granted under Rule 11 for opening new schools or upgrading schools, the power of the government under Section 20 of the Kerala General Clauses Act remained unaffected. We are unable to accept this argument because, as pointed out by the division bench, the Act and the rules do not provide for revocation of an order of sanction granted under Rule 2A5 before taking the application to the third stage and evaluating it on subjective considerations as to whether permission should be granted under Rule 11 or not. In other words, once the government approves an application for opening a new unaided school or a higher class in an existing unaided school and passes an order under Rule 2A5, then the successful applicant acquires a right of legitimate expectation to have his application further considered under Rule 9 and for the issuance of a sanction order under Rule 11 for opening a new school or upgrading an existing school. The division bench was therefore right in taking the view that the general power of rescindment available to the state government under Section 20 of the Kerala General Clauses Act has to be determined in the light of the subject matter, context, and effect of the relevant provisions of the statute. So therefore, the division bench allowed the appeals, but of course did not, pass any comment or did not make any decision on the merit of the application. So it only said that under Rule 11, because under Rule 9, there was their names were there in the sanction order, they had a legitimate expectation to be considered in the next level under Rule 11. So, which means that in appropriate cases, when the government acts in an arbitrary manner, their power to rescind a notification, that is their administrative power, is not an untrammeled power. A defense of legitimate expectation can always be raised in suitable cases. So that is what this judgment held, and a very important judgment, one of the earliest judgments. The second one is Navjyoti Cooperating Group Housing Society versus Union of India and others, 1992, 4 SCC 477. Now, these were writ petitions challenging a policy decision of the government of India that contained procedures regarding allotment of land to the Delhi Development Authority to various cooperative societies. So the High Court on various grounds had quashed it. Sorry. I'm sorry, I got a call. I'm sorry. Yeah. So the High Court on various grounds had quashed it, and Supreme Court had also upheld the order. Now, the contention that was raised in that case was, see, the basis of allotment of this land for these cooperative societies had always been based on the first come, first serve basis. So it was based on who registered first. But the new rules changed it to date of approval of membership. Now, there a plea of legitimate expectation was raised. And let us see what the court said. In the aforesaid facts, the group housing societies were entitled to legitimate expectation of following consistent past practice in the matter of allotment, even though they may not have a legal right in private law to receive such treatment. The existence of legitimate expectation may have a number of different consequences. And one of such consequences is that the authority ought not to act to defeat the legitimate expectation without some overriding reason of public policy to justify it doing so. In a case of legitimate expectation, if the authority proposes to defeat a person's legitimate expectation, it should afford him an opportunity to make representations in the matter. within the conspectus of fair dealing in case of legitimate expectation, the reasonable opportunities to make representations by the parties likely to be affected by any change of consistent past policy comes in. We have not been shown any compelling reasons taken into consideration by the central government to make a departure from the existing policy of allotment with reference to seniority in registration by introducing a new guideline. We therefore feel that in the facts of the case, it was only desirable that before introducing or implementing any change in the guideline for allotment, an opportunity to make representations against the proposed change in the guideline should have been given to the registered group housing societies, if necessary, by way of a public notice. So you see in this case, there is a change from a consistent past policy. So the court says that yes, it does defeat the legitimate expectation, but it does not straight away enforce that legitimate expectation, but it says that the legitimate expectation lies in procedure. So these allottees should have been heard before the decision was taken. So that also is an indicator of two things. One, that legitimate expectation can be based on past practice. And in appropriate cases, even if the legitimate expectation is not enforced, you will always have a right in procedure, a right of hearing. Now, the next case is Food Corporation of India versus Messrs. Kamadhenu Food Cattle Feed Industries, 1993 1 SEC 71. So in this case, the Food Corporation of India had invited tenders for supply of damaged food grains. The respondent's tender was the highest. But the Food Corporation of India was not happy with the quoted amount. And therefore, what it did, it called all the bidders for negotiation, and it asked them, including the respondent, as to whether they were willing to increase the bid amount. So the respondent refused to increase the bid amount. There was another bidder who quoted 20 lakhs more, and a tender was awarded to him. So the respondent said, see, my legitimate expectation is affected because I quoted the highest amount, and therefore I have a legitimate expectation that I will be awarded the tender. So the court refused to enforce that legitimate expectation. And let us see what the court said. The mere reasonable or legitimate expectation of a citizen in such a situation may not be by itself a distinct enforceable right, but failure to consider and give due weight to it may render the decision arbitrary. And this is how the requirement of due consideration of a legitimate expectation forms part and parcel of the principle of non-arbitrariness, a necessary concomitant of the rule of law. Every legitimate expectation is a relevant factor requiring due consideration in a fair and decision-making process. Whether the expectation of the claimant is reasonable or legitimate in the context is a question of facts in each case. Whenever the question arises, it is to be determined not according to the claimant's perception, but in larger public interest, wherein other more important considerations may outweigh what would otherwise have been the legitimate expectation of the claimant. So therefore, the claimant's legitimate expectation, according to the court, has to be determined in larger public interest, and the defense of larger public interest is always available. A bona fide decision of the public authority reached in this manner would satisfy the requirement of non-arbitrariness and withstand judicial scrutiny. So a bona fide decision in public interest can defeat the legitimate expectation of a person, is what the court held in this case. So basically, in this case, the court found that even though the highest tender was not accepted, all the bidders were called in for negotiation, and then an opportunity was given to even the respondent to increase his amount, but he did not do so. And it is always in public interest that a higher price is got to an instrumentality of a state, and it was a bona fide decision. The court felt. So therefore, the court felt it was an appropriate case to not enforce the legitimate expectation of the citizen. The next case is Union of India versus Hindustan Development Corporation, 1993, 3 SEC 499. So in this case, the railways called tender for the supply of steel bogies. So there were three companies which quoted a certain price, and the railways actually felt that they had formed a coterie or a cartel. There was another company also which quoted another price, a higher price. So what the railways did, it gave half of the supply to these three companies and the rest of the supply to the other company. So the three companies, they came forward and said that, their rate was quite low. It was the lowest, in fact. And therefore, they have a legitimate expectation that they would be awarded the entire supply. The court refused to enforce that legitimate expectation and said that, see, there was no consistent past practice in the matter of allotment. So therefore, if there is no consistent past practice, there is no basis for legitimate expectation. And let us just see what the court said in this case, because in this case, slightly the principle of substantive legitimate expectation was watered down. See, the court says that a person who claims legitimate expectation must establish that there is a foundation to make the claim and therefore has locus standi. Decision taken by the authority must be found to be arbitrary, unreasonable, and not taken in public interest. Protection of such legitimate expectation does not require the fulfillment of the expectation when an overriding public interest requires otherwise. If it is a question of policy, even by way of a change in old policy, courts cannot interfere with the decision. So if there is a change by policy, the courts will never interfere, is what the Supreme Court held. And it is generally accepted that, and also clear, that legitimate expectation, being less than a right, operates in the field of public and not private law, and that to some extent such legitimate expectation ought to be protected, though not guaranteed. So there they say, they kind of water down the concept of substantive legitimate expectation, because they say it is less than a right and it is not guaranteed. But so therefore it excludes that the operation of a substantive legitimate expectation in appropriate cases, because there may be certain cases, in the facts and circumstances wherein an enforceable substantive legitimate expectation might be there. Here, the court then says, if a denial of legitimate expectation in a given case amounts to a denial of a right guaranteed or is arbitrary, discriminatory, unfair or biased, gross abuse of power or violation of principles of natural justice, same can be questioned on the well-known grounds attracting Article 14, but a claim based on mere legitimate expectation without anything more cannot ipso facto give a right to invoke these principles. So therefore, legitimate expectation, the court says, cannot be used as a sword. It can only be used as a shield. So therefore, a defeat of a claim of a legitimate expectation must give rise to some arbitrariness, some violation of Article 14, or a violation of some kind of right, a fundamental right or a statutory right, and only then will it be enforced. So this is what the court held in Union of India versus Hindustan Corporation. So the next case is Madras City Wine Merchants Association versus State of Tamil Nadu. So in this case, this was regarding some license was given to retail sales of Indian-made foreign liquor by the government of Tamil Nadu to certain companies. So then they requested for a bar license. That bar license was also given for a fixed tenure. But subsequently, it was terminated suddenly because there were a lot of complaints which were made by people that a lot of ruckus was being caused by the bar. Therefore, bar went up to the court and said that there was a defeat in their right of legitimate expectation. So here the court held, the High Court and the Supreme Court, that a larger overriding public interest would outweigh the doctrine of legitimate expectation. And the second thing what it held was this decision to give them a license was made as a result of amendment of a rule. And that amendment was revoked. Therefore, this is an exercise of a legislative power. And in the exercise of a legislative power, there cannot be any legitimate expectation. It is only in administrative decisions that there can be a right of legitimate expectation. So that is what the court held in this case. Then you have the decision of Madhya Pradesh oil extraction versus State of Madhya Pradesh and another, 1997, 7 SEC 592. Now here, the respondent before the Supreme Court, a company, had got an order for the supply of sal. Sal is used in the production of oil. And as per a revised notification issued by the government of Madhya Pradesh, with a clause for renewal for a certain number of years. But the existing purchasers of SAL, they filed writ petitions saying that this was an arbitrary decision. But the respondent contended that this renewal clause gives them a legitimate expectation that it will be enforced and that they will get a contract for a certain number of years. So that, in that context, the Supreme Court upheld their right of legitimate expectation. And very interesting is the argument which is made by Dr. Singhvi. So Dr. Singhvi has submitted that any act or omission of the state of Madhya Pradesh leading to non-renewal of the agreement of the respondent would itself stand vitiated on grounds of illegal, arbitrary, and unsustainable exercise of discretionary administrative power, unless the state of Madhya Pradesh is able to establish specific misconduct or any serious or material lapse or act or omission by the respondents, disentitling the respondents from the benefit of renewal. Dr. Singhvi has further submitted that non-renewal by the state of Madhya Pradesh should fully justify and sustain an action by the respondents for mandamus to effectuate renewal of agreement. The legitimate expectation of the respondents as persons having agreement with specific renewal clause, which constitutes both a representation and an established past practice by the state of Madhya Pradesh, cannot be denied or thwarted unless overwhelming and specific higher public interest is shown to override those legitimate expectations. According to Dr. Singhvi, this doctrine of legitimate expectation operates in the domain of public law and is not merely a procedural right subsumed within requirements of natural justice or elementary canons of fair play. It constitutes a substantive, enforceable, and protectable interest as a facet of Article 14 itself. So you see, there an argument was made that it is a separate substantive right. And that argument in that case was upheld. So you will see that sometimes there are certain judgments that appear to be slightly conflicting, but of course it is in different facts, and therefore we need to take as judgment, each judgment as per the facts of each case. Then there is the judgment of National Building Construction Corporation versus S. Raghunathan, 1998, 7 SCC 66. So here the respondents and some other employees were taken on deputation and they were sent to Iraq for certain projects. And they were given some allowances. So their contention was that that allowance should be added to their salary and they are entitled for revision of pay scale. So that contention was negatived again because there was no established past practice in such cases and there was no promise that was made out. And it was a very clear policy decision not to, add it to their existing salary. So therefore, there the plea of legitimate expectation was negatived. So next is the case of Punjab Communications versus Union of India. I just take a moment to drink a sip of water. One second. Yes, sorry. So here, the government of India decided to take a loan from the Asian Development Bank because they wanted to provide digital wireless facility for around 36,000 villages in the state of Uttar Pradesh. Now, the petitioner before the Supreme Court submitted a tender, and that tender was, in fact, the lowest. However, the government of India later took a decision that they will not go ahead with this project because they wanted to provide digital wireless facilities in the entire country. Therefore, they decided not to take the loan now from the Asian Development Bank. So the petitioner said that there was an infringement of his right of legitimate expectation because since he had submitted a tender that was the lowest for the state of UP, then he is entitled to award to get the contract awarded at least in the state of Uttar Pradesh. So there, the Supreme Court negatived his contention. And let us see what they said. Yes, this decision is quite important because here, the Supreme Court was confronted with a question as to whether if the government changes a policy It shifts from one policy to another policy. And that defeats the legitimate expectation of a person. And he goes to court. Whether the court will go into the merits of the matter and check as to whether there is a proper balance between the public interest and the legitimate expectation, whether the action taken by the government is proportional, the proportionality test, whether that will be done, or whether the court will confine itself to look at Wednesbury principles. That is, the court will confine and just check whether the authority has acted in an unreasonable manner. So what should be the option, or what should be the approach of judicial review in such cases? So there, the court decided that substantive legitimate expectation merely permits the court to find out if the change in policy, which is the cause for defeating legitimate expectation, is irrational or perverse, or which that no reasonable person could have made. That is on Wednesbury principles alone. So therefore, the court held that a change in policy can defeat legitimate expectation, even if it is a substantive legitimate expectation. The only extent of judicial review that will be applied is on Wednesbury principles. The court is not going to look into the merits of the policy, or it is not going to look as to whether there is a proper balance of interest that has been made between public interest and the legitimate expectation of the citizen. So there, the concept of judicial review was narrowed down, and some critics point out that since the scope of judicial review is narrowed down, that in effect defeats the right itself, because once the judicial review is narrow, the enforceability of the right also becomes very difficult. So that defeats the concept of substantive legitimate expectation itself. So then after that, even the next case, I think we're running out of time, so I'm not going to go into the facts of that case. Ram Pravesh Singh versus State of Bihar, 2006, 8 SCC 381. So that case, in fact, it says that in most cases, only procedural legitimate expectation will be enforced. And that it is in very, very rare cases that a substantive legitimate expectation can be enforced. And it also says that, it will only entitle it will only entitle an expectant to an opportunity to show cause before the expectation is dashed, or explanation as to the cause for denial. Most cases, only a procedural legitimate expectation going to be enforced is what the court held in that case. And yes, then in another case, 2012 11 SCC 1, Monet Dispatch and Energy Limited versus Union of India and others. So in this case, the court recognized the distinction between the principle of promissory estoppel and doctrine of legitimate expectation. So the court held that for the application of the doctrine of promissory estoppel, there has to be a promise based on which the promisee has acted to its prejudice. In contrast, while applying the doctrine of legitimate expectation, the primary considerations are reasonableness and fairness of state action. So there also the distinction between these two concepts is recognized by the court. Then we come to, yes, I think the last three cases which we are looking into, these three cases are quite important. So the first case comes again from the Kerala High Court, and it went up to the Supreme Court. Kerala State Beverages Corporation versus PP Suresh, 2019, 9 SCC 710. 1996, Government of Kerala had banned Arak. So there were around 12,500 employees who were displaced. These displaced employees were given compensation by the state government. But however, they demanded that they be reinstated in some, post in the Beverages Corporation. Now, the government enters into an agreement with them and then enforces it by way of a notification and says that 25% of the daily wage workers post in the Beverages Corporation would be reserved for these displaced employees. Later, another notification is issued, which amends the previous notification and says, yes, we will give employment, but we will not give employment to all the displaced workers. Only the sons of the displaced workers who had perished would be given employment. Naturally, these employees go before the High Court. Single judge allows the writ petition, and then division bench hears it. 2015 SCC Online KER 35870. I read out what Kerala said. It is very important because the Supreme Court takes a contrary view. So in Kerala High Court says that it can be safely concluded that the state government have issued the said order with the intention of creating a legitimate expectation in the workers that they are entitled to acquire work as of right. If at all any change in such decision was to be made, it should have been made after providing suitable opportunity to stakeholders to represent their case in an effective manner. Such a procedure is sine qua non for observance of the principles of natural justice. Viewed in that circumstance, if the government order dated 7/8/2004 is implemented by the government with the intention of changing the policy of providing employment to 25% displaced Abkari workers, the same is an arbitrary action and therefore violative of Article 14 of the Constitution of India. So also, having legitimately expected to secure an employment by virtue of the government order dated 22/2002, right was matured to the displaced workers, thereby paving way for the culmination of a right to life provided under Article 21 of the Constitution of India. This is all the more a further reason to have provided with a hearing to the workers or their representatives before tinkering with the said order. So therefore, here, the court recognizes that a right of legitimate expectation was defeated, as a result of which there is an infringement of Article 14 of the Constitution. And secondly, it also notes that no right of hearing was given, and therefore holds that their claim is legitimate and is enforceable. And the Supreme Court takes an opposite view. Supreme Court says, an expectation entertained by a person may not be found to be legitimate due to the existence of some countervailing consideration of policy or law. Administrative policies may change with changing circumstances, including changes in the political complexion of governments. Decision makers' freedom to change the policy in public interest cannot be fettered by applying the principle of substantive legitimate expectation. So long as the government does not act in an arbitrary or an unreasonable manner, change in policy does not call for interference by judicial review on the ground of a legitimate expectation of an individual or group of individuals being defeated. Assurance given to the respondents that they would be considered for appointment in the future vacancies of daily wage workers, according to the respondents, give rise to a claim of legitimate expectation. Respondents contend that there is no valid reason for the government to resile from the promise made to them. We are in agreement with the explanation given by the state government that the change in policy was due to the difficulty in implementation of the government order dated 22/2002. Due deference has to be given to the discretion exercised by the state, as the decision of the government to the changed policy was to balance the interests of the displaced Abkari workers and a large number of unemployed youth in the state of Kerala. So therefore, it cannot be said to be contrary in public interest. And we are convinced that the overriding public interest, which was the reason for change in policy, has to be given due weight while considering the claim of the respondents regarding legitimate expectation. And with regarding to procedural legitimate expectation, the Supreme Court said that each and every person cannot be given a right of hearing. In fact, in this case, the representatives of the workers were given a right of hearing. And Supreme Court said that, a defeat of a procedural legitimate expectation alone, in most cases, will not entitle or will not result in quashment of the decision of the government. So you see how two courts have taken two diametrically opposite views on the enforceability of a legitimate expectation. Then this is the latest judgment of the Supreme Court, 2020 SCC Online SC 968, State of Jharkhand versus Brahmaputra Metallics Limited, Ranchi and another. I will deal with this judgment and then the Delhi High Court judgment, and then I will stop. So this judgment, State of Jharkhand announced its industrial policy in the year 2012. And it said that certain rebate or concessions would be given in the supply of in electricity duty for a period of 5 years. So it was stated in the industrial policy that the respective departments would notify this within 1 month, because according to the rules, only after the respective department notifies can the contents of the policy be given effect to. What happens? As usual, administrative delay. This is not notified at all. Only in 2015, after the writ petition is filed, the respective department notifies this industrial policy. And after notifying this industrial policy, they make it prospective. So what happens? Writ petitioner says that, see, 2012, the industrial policy came. It was supposed to be notified within 1 month. So if it had been notified within 1 month, I would have got a period of 5 years exemption or concession in electricity duty. But now it is notified only in 2015 and made prospective, which means I get the exemption or the concession only for 2 years. Therefore, this defeats my right of legitimate expectation, because there was a clear policy. And that policy very clearly stated that for a period of 5 years, this concession would be given. So Supreme Court in that case upheld the legitimate expectation. And what it said is extremely important. States in the present case held out a solemn representation, and this representation was founded on its stated desire to encourage industrialization in the state. A deprivation of the entitlement of private citizens and private business must be proportional to a requirement grounded in public interest. Since the state has offered no justification for the delay in issuance of the notification or provided reasons for it in being in public interest, we hold that such a course of action by the state is arbitrary and is violative of Article 14. So please see that the court says that deprivation of the entitlement of private citizen and private business must be proportional to a requirement grounded in public interest. So court is departing from the Wednesbury test and moving towards the proportionality test. Here the court is not looking as to whether it is not confined to looking as to whether the decision of the state is unreasonable, so unreasonable or not, but it is actually going into the decision and looking at it from a proportionality angle. It is looking and it is in fact reviewing the decision and checking whether an adequate balance has been made between public interest considerations and the legitimate expectation of the citizens. So that is, I think, a positive sign for the doctrine of legitimate expectation, and especially the doctrine of substantive legitimate expectation. Now, finally, we will see if the Chief Minister and the government of NCT of Delhi was asked to pay the rent or not. Yes, it was held that there was a solemn promise that was made, and it was held that the promise or assurance or representation given by the Chief Minister clearly amounts to an enforceable promise, the implementation of which ought to be considered by the government. Now, just a very interesting paragraph which the court says. While the court cannot assume the discretion which exists with the governmental authorities, the authorities ought to follow a rule of reason. There has to be a reason as to why the government has simply chosen to disregard or fail to implement the promise or assurance given by the Chief Minister. The said assurance is not a political promise as is sought to be canvassed before this court. It was also not made as part of an election rally, circumstance of the promise. It is a statement made by the Chief Minister of the National Capital Territory of Delhi. There is a reasonable expectation on behalf of the citizens that the Chief Minister knows the background in which such a promise is made, the number of people who would be affected by the same, as also the financial implications of such a promise or assurance in the context in which it was made. Statement was not made by a government functionary at a lower level in the hierarchy who could be devoid of such knowledge. The Chief Minister is expected to have had the said knowledge and is expected to exercise his authority to give effect to his promise or assurance. To that extent, it would not be out of place to state that a reasonable citizen would believe that the Chief Minister has spoken on behalf of his government while making the said promise. The said promise was to act as a balm on the wounds of landlords and tenants who were severely affected as a class of citizens in Delhi. However, the lack of any decision to implement or a conscious recent decision not to implement has resulted in a non-decision in respect of the legitimate expectation of its citizens. The statements made by persons in power are trusted by the public who repose faith and believe in the same. Thus, puffing, which may be permissible in commercial advertising, ought not to be recognizable and permissible in governance. So therefore, here, the court again notes that, see, the government had not taken any decision with respect to enforcement or non-enforcement. So it directs the government within a period of 6 weeks to take a decision as to whether this promise is going to be enforced or not. And it also directs them to weigh considerations of public interest as well as the legitimate expectation. And it also directs them to frame a clear policy in that regard. And also because of course the bona fide of the claim needs to be examined, the bona fide of the claim of the tenants and landlord. So therefore, a positive order the court is not passing, but it gives them time to frame a policy within a period of 6 weeks. And it also gives liberty to the tenants and the landlords to challenge whatever is the outcome. So therefore, this in essence is the doctrine of legitimate expectation. And we have seen decisions from 1988 till the latest decision. And I think to summarize, yes, the concept of legitimate expectation in administrative law is recognized by the courts in India. Both substantive legitimate expectation and procedural legitimate expectation is recognized. But in most cases, it is procedural legitimate expectation that is enforced. Substantive legitimate expectation, yes, it is enforced provided that you show that there is some arbitrariness or it has led to a violation of Article 14. Only then it is enforced usually, because it is seen as a sword. It is seen as a shield and not a sword. And the degree of judicial review with respect to legitimate expectation is quite narrow. Usually, especially if it is a case of change of policy, it is only the Wednesbury test which is applied and not the proportionality test. But these two judgments indicate that the court does in appropriate case apply the proportionality test to decide if a substantive legitimate expectation should be enforceable or not. And lastly, I think, it is up to us lawyers to craft, this doctrine in suitable ways to ensure, I think, that legitimate claims of every citizen is enforced. Because the whole idea or the concept behind this doctrine is to ensure that there is a certain amount of accountability, non-arbitrariness, and consistency in government decisions. Of course, the government is going to be free to, change its policy. That is not, what I'm talking about. But sometimes, the government acts in a completely arbitrary manner, and sometimes there is absolutely no accountability. So in such cases, I think as lawyers, we can craft and apply this doctrine in suitable circumstances to ensure that the legitimate expectation, a legitimate grievance of the citizens are redressed. So that's all. I'm sorry. Sorry. It's such a big concept. Okay. Thank you again for the opportunity. It was a great honor. Thank you so much.